3 years before anyone died, someone wrote it down. A Union Carbide safety auditor visited the Bhopal plant in 1981 and noted that Tank 610 was operating outside acceptable parameters. The report used the phrase, "runaway reaction." No corrective action followed. On the night of December 2, 1984, a plant worker named Suman Day reported that gauges near the methyl isocyanate storage units were behaving unusually. Pressure readings were climbing. There was a smell, sharp, faintly sweet, that workers had learned to associate with small leaks. Day and his colleagues assumed a minor release. They had assumed minor releases before. What happened next was not minor. Approximately 40 tons of methyl isocyanate gas escaped from Tank 610 into the air above Bhopal, Madhya Pradesh. Methyl isocyanate is heavier than air. It moves low and fast. It does not disperse in the way that smoke disperses. It settles into the spaces where people sleep. In the shanty settlements immediately surrounding the plant, families were in their beds. The gas reached them before any alarm did. Survivors described a sensation of fire behind the eyes, then a heaviness in the chest, then nothing they could adequately explain afterward. The streets at dawn contained people and animals and birds. None of them were moving. Estimates of the immediate death toll range from 2,000 to more than 3,000. The figure of 15,000 is the number most frequently cited for total deaths attributable to gas exposure in the weeks, months, and years that followed. Epidemiological studies conducted in the affected areas found elevated rates of respiratory illness, neurological damage, and pregnancy complications extending into the next generation. The Indian Council of Medical Research collected tissue samples and health data from survivors for years. Much of that data was never published. The Council's own researchers later said the data had been classified by the Indian government. Union Carbide's response in the immediate aftermath followed a recognizable pattern. The company dispatched a team to Bhopal. It acknowledged the disaster in public. Warren Anderson, the chief executive officer, flew to India on December 7, 1984. He was arrested by Indian authorities upon landing, charged with culpable homicide. He was released on bail within hours. He flew back to the United States. He never returned to India. He lived until 2014 in Vero Beach, Florida. He gave no public interviews about Bhopal in the final decades of his life. Indian courts issued multiple arrest warrants in his name. The United States government declined to extradite him. The 1981 audit existed. Union Carbide had acknowledged its existence in internal correspondence. The audit had specifically identified mic storage conditions at the Bhopal facility as presenting unacceptable risk. The language was precise. The recommendations were concrete. Refrigeration systems for the mic tanks were described as inadequate. Emergency scrubbing systems were flagged. The flare tower designed to burn off escaping gas was noted as potentially undersized. When investigators examined these systems after December 3rd, they found the refrigeration unit had been shut down months earlier. They found the scrubber was offline. They found the flare tower, when it finally activated, was insufficient to handle the volume of gas that had already escaped. Each system that had been flagged in 81 had either remained unrepaired or had been subsequently disabled. Union Carbide maintained that the disaster was the result of deliberate sabotage by a disgruntled employee. No independent investigation substantiated that claim. The legal proceedings that followed took 5 years to produce a settlement. The Indian government negotiated on behalf of the victims. In February of 1989, the Supreme Court of India approved a settlement of $470 million. Survivors' groups had sought $3 billion. Documents later obtained through civil litigation in the United States revealed that Union Carbide had internally estimated the settlement cost in advance. The figure the company had modeled as an acceptable outcome was close to the figure ultimately agreed upon. The documents did not explain how the company had arrived at that estimate before negotiations concluded. The settlement released Union Carbide from all further civil and criminal liability in India. The plant in Bhopal was abandoned after the settlement. It was not cleaned. Union Carbide had stored significant quantities of chemical waste on the site during its years of operation. That waste remained. Union Carbide was acquired by Dow Chemical in 2001. Dow stated that it bore no responsibility for the Bhopal site since the acquisition had not included assumption of prior liabilities. The site continued to sit. Rain moved through it. Water moved downward, as water does. In 1999, Greenpeace conducted environmental testing in the soil and groundwater surrounding the abandoned plant. Researchers found mercury at levels between 20,000 and 6 million times the concentrations considered safe under Indian government guidelines. They found other compounds, chlorinated solvents, organochlorines, metals. Some of these compounds had no plausible origin other than the plant's historical operations. Children in surrounding neighborhoods were found to have elevated levels of toxic compounds in their blood. The testing was conducted 15 years after the disaster. The contamination had not diminished, it had moved. The case against Union Carbide's Indian subsidiary proceeded separately in Indian courts. In 2010, 7 former employees of Union Carbide India Limited were convicted of causing death by negligence. They received sentences of 2 years each, the maximum under the charge. Several of them were in their 70s. Warren Anderson was listed as a defendant. The court noted that he could not be compelled to appear. The 1981 audit report cited Tank 610 by designation. It described the conditions that would, 3 years later, produce the worst industrial accident in recorded history. It was written, reviewed, filed, and set aside. Someone signed it. That signature is in a document that exists. What is harder to establish is what the person who signed it understood in 1981 about what they were setting aside, and whether that distinction between understanding and choosing not to act on that understanding has ever, in any jurisdiction, made a legal difference that lasted.